Well, thank you so much for joining us. For those of you who I've not met, I'm Rayleigh Honeycutt. I serve as the Executive Vice President of the Montana Stockgrowers Association. Today we are hosting a water symposium. Obviously, water is a big topic for our membership and has been a conversation that we have been engaging in for many decades. In recent years, there's been a lot of conversations around exempt wells and water during the legislative session, and so what we thought we would do today is just kind of provide a water update on legislation as well as just basic water law. Our hope is that this kind of helps build the foundation as we move into our policy discussion in the next hour and a half. And so I am excited to introduce to you two of our speakers today. For those of you who do not know, Montana Stockgrowers recently engaged with a law firm to be our legal counsel, and as part of the firm's portfolio, they offer water attorneys as one of their services. So we have Abigail Brown today with us with Parsons, Beal, and Latimer. She will be providing kind of some basic water law background for all of you. And then we also have Anna Pakenham Stevenson with Montana Department of Natural Resources Water Division Bureau to talk to you a little bit about legislation and bills that we have seen in the past and what laws did pass and what is going into effect now, October 1st and January 1st. So with that, I'm going to hand it over to Abby, and then we definitely want this to be an engaging and interactive event, so feel free to ask questions throughout, and these ladies are teed up to answer those for you. So without further ado, Abby, thanks for joining us.
Thanks, Rayleigh. For those of you who don't know me, I'm Abby Brown. I'm an attorney at Parsons, Bailey, and Latimer. I do specialize in water and water rights. I've been in private practice a little over 15 years now, almost all of that in the water rights world. So what we thought we would do today is break our presentation into kind of four main parts. I will give a Water Law 101 overview, really just to set the stage. Anna will talk about some 2025 legislative updates, what's new, what's going into effect, deadlines you might need to know about. Then I will give an overview of exempt wells. What are they? What is the status? That's been in the news and in this past legislative session a lot. And then Anna will talk a little bit about what else is happening in the Western United States in terms of water rights. We will take a pause after each of these sections. If you have questions, comments, please feel free to ask them. We will have a larger question and answer discussion at the end, but an hour and a half can be a long time, so don't hesitate to interrupt and ask any questions you have. So, starting off, Water Law 101. Montana is a prior appropriation state. Most of the Western United States are prior appropriation states. It's important to know, though, that water law is state-specific. So if you're familiar with prior appropriation law in other states, it may not be exactly the same as Montana. But generally, in a prior appropriation state, first in time is first in right. This relates to the priority dates of your water rights. The more senior your water right, the higher you are in priority. And generally, if you have a senior water right, you get to satisfy that entire water right before the next junior user. So this comes into effect primarily in times of shortage when there's not enough water on a source. Another key point of Montana water law is that the state owns the water in Montana. Your water right is the right to use the water. It is called a usufructuary right. You have the right to use it. That is what your water right claims are. They are telling you the parameters of how you can use those water rights. Water rights in Montana are a property right, meaning they can be bought, they can be sold, they can be conveyed with or without the land, as long as you are following the various applicable Montana law. A third point to keep in mind, especially as we go through the discussion today, is that in Montana, we do not have preferences among types of water right. And when I say types of, or water uses, I'm talking about domestic, livestock, municipal, irrigation, development. All types of uses of water in Montana are treated the same. We are not a state that has a preference. In Montana, groundwater and surface water is treated as connected. This was established by litigation in the mid-2000s. And generally, a water right, you have to look at beneficial use, an intent to apply the water for use. In Montana, as with other Western states, beneficial use is the basis, the measure, and the limit of your water right. This prevents speculation of water, so you can't just hoard water and hold it on hoping to use it. If you have a water right, you need to put it to beneficial use in order to maintain that water right. And finally, the final point, water rights can be abandoned in Montana. An abandonment is a fact inquiry. It is decided in a court, and there are generally two parts to abandonment of a water right. There is a period of non-use and an intent to abandon or an intent to stop using the water. Water rights are valid until they are found to be abandoned. This is important to know, I think, because a lot of times we hear the phrase use it or lose it, and that is correct to an extent, but there are other Western states that have forfeiture, and forfeiture means that if you don't use a water right for a designated period of time, then your water right is terminated. So for example, if you don't use your water right for 5 years, it's automatically terminated. That is forfeiture. We don't have that in Montana. What we have right now is abandonment, which is a judicial proceeding.
And there's no specific time frame on abandonment, is that correct?
That's correct. The question is there a specific time frame on abandonment? Not really. What you probably hear most often is 10 years is like a benchmark, but what case law says is a long period of non-use. That is why it's tied with that intent piece, because the time period could be shorter. If, for example, you're talking about an irrigation water right and you fill in the ditch, put a road over it, and can't use it, the time frame might be less. So there is no specific time frame. Yes. So after their final decrees, there is a 10-year, but it raises the presumption of abandonment. So there is a statute that after adjudication, after we have final decrees, if there is non-use for 10 years, it raises the presumption of abandonment, but it still doesn't automatically terminate the water right. And that is why we have that, people talk about that 10 years. So that's kind of the water law, the main points of water law. There are different types of water rights in Montana. I think that's important as we continue our conversation today. There are what are called existing water rights. These are your statements of claim. They are the water rights that have priority dates prior to July 1st, 1973. These are the water rights that are being adjudicated through the Montana Water Court and were constitutionally protected. That is the second type of water right in Montana are your water permits. These are all new uses of water. Typically, they have priority dates, June 30th, after June 30th, 1973. They are authorized by DNRC or the Department of Natural Resources. You can have an existing water right that you make changes to. That change, if it happened after 1973, also goes through the Department of Natural Resources, and they have a process for that. So in 2025 today, the only way to get a new water right is to get a permit. There are no more existing water rights. There are also limited exceptions to the permitting process, and this is exempt wells, which I will go into in more detail later, but there are limited exceptions. And then there are federal reserved and tribal water rights also in Montana. The DNRC has a great website that lists all 18 of the negotiated compacts. Each compact is unique, so if you're in an area that's affected by one of these 18 compacts, I always recommend looking at it to see how it might affect your particular area. And this is with Indian reservations and various federal lands, is where the compacts exist. So that is like high-level 101 water rights. I will pause here if there are any other questions, and then Anna will talk more about what happened in the 2025 legislature. The purpose of this is really to set a stage. Yes, sir.
Talk just a little bit about the development of a new water right. I guess it's no secret in central Montana, Water Authority, there are now, I think, 5 or 6 very deep wells that are coming online.
So the question was to talk a little bit about new water rights. And I think at a high level, to answer that, it depends where you are in the state of Montana. So in Montana, we have some areas that are closed to new appropriations. These are closed basins. We have some areas, mostly in eastern Montana, that are not closed to new water rights, and therefore you can go through the permitting process to get a new water right. This applies to surface or groundwater rights, or groundwater use. So if you are using new water, then you have to go through the permitting process at DNRC. And since we have Anna here, she can probably give more.
So thanks for the question. To dive in a little bit deeper, when you're going through the permitting process in statute and rule, there are criteria that must be met, and that's different than the exception. So in the permitting process, there are criteria like, is water physically available? Can I see it in the creek? Or is there water in the aquifer if we're talking about groundwater? Is it legally available? So water could be physically there in the creek, but it belongs to, as Abby was talking about, the prior appropriation system, it could belong to Bob and Sue and Jimmy, and all those water rights have allocated all the water you see. So it wouldn't be physically available, but it's physically available, but it's not legally available. You have an adverse effect criteria. Are you going to adversely affect somebody by taking that water with a new water right or permit? Can you put it to beneficial use, that anti-speculation that Abby talked about, and do you have possessory interest? And so when a new permit is applied for, you have to prove that to the department in the application process. That is what the department is reviewing for. In addition, there is a notice and objection period for permits and changes. So the notice goes out to impacted parties. We also have an online water rights notification tool. If you haven't signed up for that, I would really encourage you to do so. You get a notice that, hey, Susie is applying for a new water right, here is the application. You have the opportunity to say that those criteria that are established are not being met, that that new water right could have an adverse effect, or I disagree about the physical availability. So that is the notice, and if you disagree, you now know about it and you have the opportunity to object. And then that goes through a whole process.
But how do you object to, say, multiple wells? How do you object to any kind of proposed water development when that process has to be done before the permit's issued? And you can't really tell if there's any adverse impact before it goes online. And when it goes online, and it's serving 4 or 5, maybe 6 towns now, and no one has seen any adverse effect, but I don't know that anybody's measuring it. And that's my concern, is measuring the use so that all the downstream wells are impacted, but you don't know till it's up and running.
Great question. So how do you know there's an impact? How do you know until it actually goes online was kind of part one, and part two was the measurement and reporting. I'm going to take the first swing, and I'm sure Abby's going to want to back clean up after me. So the first swing is when that application is applied for, they have to demonstrate those criteria, right? And that is what the department's evaluating. When you get notified, you're going to look at that same information, and you can look at it yourself. and that is your opportunity to object. I want to note, though, and Abby, on this slide here, there's the traditional permitting process where we talked about all these criteria. The exception does not have those criteria, and I think everyone knows that, but I want to say it one more time. Those physical availability, legal availability, adverse effect, beneficial use, possessory interest are not criteria for the exception or an exempt well. In addition, if the person who you're talking about is using the exception, there is no opportunity to be notified, and there's no objection. And so it really depends on the application process. The second part of your question is what about, no one's measuring or reporting? The state of Montana is pretty unique in western states where we don't have measurement and reporting statewide generally. And this is something that needs to be a policy consideration for the state. In order to protect your water rights from abandonment, you got to know what you have. In order to know that someone's not impacting you, you have to have that information. So that is a policy discussion that is worth having. In particular, in statute today, under 85.2.113, exceptions to the permits or exempt wells cannot be measured or reported. I'm sure you want to back clean up.
I don't know if it's cleanup, but I do want to add something else I heard from your question, which was, let's say the permit was issued and now you're wondering, is there an adverse effect, or now you're finding that it's adversely affecting your water rights. Now we're in the enforcement or administration of water rights, and the measuring and reporting is important. And I think that as new permits are issued, the permits are having requirements of measuring and reporting. The question is, who gets that information and where does it go? I agree with Anna, that is a policy discussion that the state of Montana needs to have. We do not have a robust statewide measuring and reporting system. But if a permit has been issued, now you find that it's impacting your existing water rights, we go back to the priority system. And if you have senior water rights that are being impacted by a more junior permit, then your options are usually to go get a water commissioner. And so that is, in Montana, we do that through the courts, and you can there's the informal way. You can call the junior water user or permit operator and say, you're impacting my senior water rights. I'm going to make a call or ask you to stop using your water because I am senior and I get to use all of my water before you start using it. Sometimes that works, especially on small creeks or in areas where everybody has known each other. There's an informal system of making sure everybody shares in a limited resource. But if that doesn't work, then the next step in Montana is you can go and get a water commissioner, and you go to your local district court and you file a petition for a water commissioner. You designate kind of an enforcement area, and then that commissioner has to go out and make sure everybody's using their water in priority. That is the system we have kind of right now if you are being it. But I think the crux of it is what you said, which is if you're not measuring and monitoring, then you don't know if you're being impacted or if something's happening.
Gene, could I jump in just for a sec? Yeah. I wanted to formally make sure everybody was aware that this meeting is being recorded. And then, of course, Rocky will have mics over there, and we'll get mics to anybody with questions.
Well, I just read into Jim's question a little bit more, and that's the crux of everything we're going to probably talk about today, the fact that this water is going to communities. So when I make a call that said this well is affecting my senior water right, but it's affecting, if that call is granted, then it's going to affect the livelihood of numerous people downstream. That's the whole crux of the whole issue that we're going to talk about today, I believe. And so what's the answer if Jim makes the call that well that's feeding Roundup and Levina and whoever, I don't know what towns, but he makes the calls, and so they get shut off. Where's agriculture going to be then? So.
Yeah, And that is a great, that's a great point. And Montana is a strict prior appropriation state that does not have preference. So if somebody is making a call and they are senior, that is what commissioners are looking at and not how the water is being used. I think that is a policy conversation for the state as we move forward.
Just Jim, right there, right back there.
Can I add to that before we move on? 100%, and that policy discussion is really important. In addition, one of the things we can strive for, and in Montana, we're headwater state, we're generally low population. We can strive to be proactive and know and manage to not go to over appropriation, manage where we are seeing problems so that we're not giving out more water than is available, so that we're not setting ourselves up for a situation where we do have to cut off people, right? That is the proactive place that we still in some areas have the opportunity for.
Hertha Lund, I think in the Crazy Mountain Ranch where they were taking the water for the golf course, one of the first things they did was actually get a commissioner, and the commissioner took action to say it was, they couldn't use it for that. So that's an example where the call system did work, and then they found another way to get more water. So if I got the facts correct.
Yes, they do have a commissioner there, and that is one of the ways that those irrigators and water users protected themselves, yes.
I just wanted to clarify this a little bit. Everyone is really welcoming this new water. I mean, I'm not kidding you. 5 or 6 towns now are getting good water out of it. And there are 5 wells there, all within, I would say a quarter mile of each other. And it's beautiful water. But there's a lot of agriculture people downstream. Not a lot, but there's some more wells downstream that have a much higher priority date, and when it gets to the political side of things, and it's agriculture versus 3 rural towns, that's a dicey one.
Yes.
So I'll just reintroduce myself. My name is Anna Pakenham Stevenson. I'm the Water Resources Division Administrator at the Department of Natural Resources and Conservation. Our division does water rights, adjudication, enforcement, and distribution. We own 22 state water projects and do 250 miles of irrigation canals. We do floodplains and dam safety. We have a science bureau that provides most of the hydrology for the state and our decision making. And then we have compact implementation and planning and communications. So I want to highlight some of the recent water bills that passed in the 2025 legislative session. We have a bunch of legislators in the room, so just want to give a hearty thank you for passing these bills. And then in addition, these bills were the brainchild and the really hard work of a diverse stakeholder working group, which Ray Lee and Abby both participated in to develop these innovative policy solutions in partnership with the DNRC. So 6 major pieces of water legislation to pass. It's pretty landmark here that we were able to pass such important pieces of water legislation. So there were 5 that went into effect in October 1, and then 1 goes into effect on January 1. And I'm going to go through each one of these at a high level, and if you have any questions, please interrupt. Okay. The theme around all of these bills you will see is, as we continue to have more water challenges in the state of Montana, how do we provide flexibility for the water user? How do we create streamlined processes? How do we create more opportunities? General theme. So Senate Bill 178 was the temporary lease of a water right. This was a previous statute that was in effect. It sunsetted, and we revitalized it with some significant changes. And this bill allows an owner to voluntarily, temporarily lease their water to somebody else. It gives that flexibility we're talking about to meet our growing needs while ensuring that notice and objection for potentially affected water users have that opportunity. So there's always this balance, right? How do we allow for new uses while protecting that senior water right holder? And one way to protect the senior water right holder is our notice and objection. So people in this room hard fought for making sure that notice and objection were included in this bill. So you're allowed to temporarily lease your water right. You can lease it up to 40 days per year and up to 5 consecutive years in a 10-year period. So it's limiting how much you can lease it, but it gives that flexibility to give it to somebody else. The lessor, the person who's letting their water be leased, cannot use their water at the retired place of use. So if I have this place of use, this crop that I don't want to irrigate this year, I can lease it, always Bob, to Bob. Bob can utilize that water right for 40 days per year in 5 consecutive years in the 10-year period. DNRC will approve or deny. There is the opportunity for objection, and it's on the DNRC Form 605. So it's a reinstating of that statute, providing some parameters here to ensure that the protections for senior water right holders, while giving that flexibility that people really benefit from. Let's see. So, yes, please. Yes.
Does the point of diversion come into play on a leased water right? Or does it have to come out of the original point of diversion?
It does not need to come out of the original point of diversion. It is you're limited to the existing water right, but it can be applied somewhere else.
So if that point down river, downstream, down whatever, if that point of diversion is that water right that is seen water rights that are between and the one that the
The question is version moves, and I apologize, I'll have to re-clarify. I don't remember off the top of my head all the criteria. The bill assures that you can use someplace else. I'm not 100% positive about the POD change. I will say that if there is an impact to a senior water right holder, you still maintain that ability to make that call. And so if the POD there's someone impacted that previously wasn't, the bill does provide for the insurances that impact is accounted for. But I will do a follow-up with Ray Lee to get clarity on how we look at the point of diversion. I don't know if you remember from session. No. Okay. The next bill was waiver of adverse effect or Senate Bill 190, consent to approve of an application. Again, back to those different criteria: physical availability, legal availability, adverse effect. It's reinstating the provision allowing a water right owner to voluntarily remove their water right from consideration by the DNRC for adverse effect. This does not impact physical or legal availability. It is only the adverse effect criteria. Previously terminated in 2023 to a sunset provision. It was reinstated. And again, the importance here is it again gives the owner the option to opt into that flexibility on adverse effect. We've seen this be used primarily by FWP, primarily because of that adverse effect. I think this is a good stepping stone for flexibility. The waiver of adverse effect is one criteria. Other Western states have other criteria that can be waived, and I think that's a policy area for discussion. Keeping with the theme of flexibility, the next is the exception to the change process. So the traditional change process, you're changing your point of diversion, place of use, purpose. You do have to go through a change process, and it takes some time and resources. Effective October, there were kind of 3 changes to the exception to the change process. One is simplifying replacement wells by changing that flow rate and volume limitation to proximity. The flow rate and volume limitations really limited who could utilize it, and it really changing it to a proximity within 200 feet was more meaningful to ensure that there weren't adverse effects. So If you have a well and you just merely want to move it over there 200 feet, you no longer have to go through a full change process with us. This is important for stock wells in particular. You don't have to go through the very expensive and long process for a change. You can apply for an exception. It creates a process for adding a place of use for municipalities and county water sewer districts. So we see multiple places of use being served by counties and municipalities. Often we see them trying to grow. They wanted that flexibility to grow and modify their place of use, but not impact senior water right holders. So the way they did that and the bill was drafted was you can't increase your flow rate or volume. You're limited to within the boundaries of a land use plan or a growth plan. So you're still constrained by your unused portion of your water right, but you're now having some flexibility to add your place of use. And then also important is an exception for adding stock tanks to stock water rights. This is something Rayleigh spent a lot of time advocating for. If you just want to add another stock tank to your existing water right, go ahead and do it, as long as you are staying within your flow rate, volume, and number of stock. So you're not expanding your water right, you're just adding another place that water can be accessed. Any questions on that one? Okay. House Bill 441, alignment of provisional water rights with final decrees. Recall that Abby was talking about there are existing water rights pre-July 1, 1973, and new water rights or new appropriations post-July 1, 1973. And the way the state and the legislature set up this system was these would be going along merrily on their separate paths, but one day they had to come back together and create kind of one system that talked to each other. And so this bill does that. It really creates that certainty and finality in due process, both for adjudicated water right holders and provisional permit holders after state water adjudication and final decrees are issued. You're probably not aware, but if you have a new water right and the basin hasn't been put into final decree, that water right is provisional. It is not finalized. So this bill allows that finalization of those things to come together. So real clear process for how adjudicated water right holders can petition DNRC to reduce, modify, or revoke provisional permits based on the final decree. So the legislature told the DNRC, go forth and continue to issue permits. We're not going to wait for the adjudication process to be complete. But now we have basins in final decree, we have the opportunity for the department to consider what was in that final decree. Ensures that DNRC's verification of changes considers the findings in the final decree now that it's available to us. It creates a process for issuing certificates of water rights for provisional permits and change authorizations, because now we have an ability to bring those two processes together. And while it was effective October 1, there was no required action from the DNRC until January 31st, 2026. So I think it's really important to talk about what this process looks like and your obligation if you do want to participate. So here's a flow chart. The final decree gets issued or the effective date of the bill. There is 60 days the department will give notice to people in the basin, 180 days for a petition to be filed. There's the deficiency process that's typical. There will be a response and then a DNRC decision. The thing to really highlight here is that after the notice that goes out, your action is 180 days to file a petition. With changes, there is a change filed, a final decree is issued, or the change is completed. The owner, we have to verify that it's in substantial accordance with the bill or the change application. We do our verification process. It has to be in accordance with the terms of the application for the changes, in accordance with the final decree, in accordance with any petitions in place. And then there's the opportunity for a show cause hearing. So I'm going to take a pause here, and I know that many people will probably have some interest here. So again, Many of you probably have statements of claims, have been going through the adjudication process. This is the opportunity for a petition that if a new permit after July 1, 1973, ensuring it's in substantial accordance with the final decree, and if the final decree had been available to the department, it would have been denied or modified. Hertha, I'm sure you, yeah.
Hi, Anna. Who hears the show cause hearing?
The Office of Administrative Hearing.
So that's an administrative proceeding before the DNRC.
Yes. That's consistent with all of our decisions. Great question.
So Anna, I had a question on 178, just, that seemed like a contradiction, if you can explain it to me.
Yeah.
That says you can lease for up to 40 years, and you can't use the water in any year on that retired place. So if I lease my water from May 20th to July 1st, why can't I use it in July and August? Or if I can't use it in July and August, then didn't I essentially lease it for more than 40 days?
So the question was, why the 40 days and why do I have to retire a place? Yeah, that's a great question. You're balancing between ensuring you're not expanding your use and our ability to verify that. And so we want to make sure that part of the bill talks about you're within your historical consumptive use. Without doing a full historical consumptive use analysis, not using the water in that place verifies that you're not double dipping, right? And so the way the bill was drafted is, say you have a plot and you actually only want to irrigate half of it this year and you want to lease the other half. That half that you're leasing, you retire that for that year. The other half you can use. Because we're not doing full criteria analysis and the historical consumptive use analysis, the only way that someone can look and verify there isn't that expansion is the non-use of that acreage.
Thank you. I had another question back and clear up, Abby. You'd mentioned that we have no types of water rights in Montana, but you also said, this was potentially a policy issue that we should be talking about. So does that mean that this lack of preference is a statutory issue? It's not constitutional?
I would say that by statute, the legislature could decide to have preference amongst types of uses. There are other Western states that do that. I think in that policy discussion, that would be the discussion of, is this constitutional or not? And how do we, because we have the pre-1973 water rights, those are the ones that are constitutionally protected. And provisional permits, water rights after July 1, 1973 don't enjoy that same constitutional protection. So some of that policy discussion would be, can you apply a type of a preference of use to all water rights? Can you only apply it to provisional permits? What does that look like? So it's a complicated answer, and the discussion comes from a lot of other Western states that do have that preference, and you might be talking about that some later.
Can you differentiate between preference of use and limitations of use types? Those are two different things. Oregon has highest and best, which is domestic versus there. Yeah. I think it's also important, just like Abby said, we don't have a preference for use. An example would be Oregon. I think I am recalling from a while ago, in-home domestic is the highest and most important use, isn't it? And trumps throughout statute when there's a conflict between uses. Like Abby said, we don't do that, but we do, for example, in the exception, we allow for geothermal, firefighting, and other uses, and we also limit by use type, which is slightly different than preference by use. And I think it's important to realize those are two different concepts, and I think sometimes they're conflated. Yeah.
As a follow-up, and you can see what I have to put up with at home now, right? Anyhow, follow-up, do any of the other states have the provision that we have with constitutional protections for those senior water rights? I don't think so,
I
but
don't know, Hertha, do they?
I don't think so, but I don't know for sure. I think that's unique to our Constitution, but I haven't ground truthed that.
That is my belief, but I also haven't looked that up. I could certainly follow up, but I think that is the case, that we are unique in that way. Montana has dealt with our water rights in a way that is unique from other western states. So I will put that on my list to follow up, but I think that is true.
Okay, 2 more bills. I promise they'll go quickly. Clarifying water right abandonment. Abby, you did a great job of clarifying what is abandonment versus forfeiture, and I think that's a really important component here for Montana. But we want people to participate in drought management plans if they voluntarily want to, right? We want that decision-making to happen at the community level with your neighbors. And if you're developing a drought management plan, the bill aims to provide protections from claims of water right abandonment for those participants who are engaging in this activity. It's pretty simple. If you're participating in a drought management plan, and that those voluntary conservation actions, they cannot be the basis for a claim of abandonment. Just gives you that a little bit of additional protection. Finally, probably yes, sir.
How many water right claims have been abandoned in Montana? Any idea?
I don't know the answer to that question, but I do know that a judicial challenge alleging abandonment is a difficult one to bring. And I would suspect that we have a lot of what I would call paper water rights in our system, which are water rights that probably, were they challenged, could be found abandoned, but are not challenged. And part of that is, I think, because you have to allege abandonment and then bring that challenge right now, that somebody has to do that, and often it falls on the neighbor or someone else on the source.
I guess I would say I would imagine very few, given the hurdle and burden to go through that process. And again, forfeiture in other Western states is period of non-use for a certain amount of time, it gets off the books. So something to consider. Okay, the last bill is agency coordination bill. I'm going to move forward and then move back. If you're a visual learner, which I am, you know that for development, there is the Platting Act. So it goes through counties and local government for the division of your land. The Sanitation Act, which is through the DEQ for sanitation, your engineering, your water quality issues. And then generally, at the very end, if you want to use water, you're hitting the Water Use Act, which we employ here at the DNRC. When development occurs, has always been a disconnect between these 3 acts, and statutorily there is a disconnect. So you begin your process, you get approval from counties and local governments, from sanitation and DEQ, you divide your land, you build your home, you use your water, and then you get a water right with the exception after those things happen. Your approval comes at the end of the process, and this could be a long period of time. Subdivisions were relying on the hope of the exception in many cases for the use of further water use in their development. The DNRC and the DEQ tried to bridge this gap between our acts through a subdivision review letter and being clear that it's not a water right, and we are still having a final decision at the end of the process. But if you've been in tune with any of the recent newspaper articles, there has been a lot of people caught in this limbo land where they thought they could use the exception, and with changing courts' decisions, could no longer use the exception anymore. So huge gap between the Sanitation Act, Platting Act, and the Water Use Act. Senate Bill 681 brought those 3 processes together so that there was more clarity on that. So let me go back. So the goal of the bill was to provide concurrent processing timelines for DNRC's water rights and subdivision applications. It's allowing the local authority to have certainty that water rights, either through the exception or the permit, when going through the approval. And if a water rights permit is being applied for, so not going through the exception, that the technical analysis or the bread and butter of the information that is coming out of the permit can be used to determine the physical availability. It's allowing for local reviewing authority to condition subdivisions through the Platting Act so that the water right approval has to occur, and providing certainties to individuals planning on using groundwater development under the exception, that they have some certainty that they're going to qualify before they invest all this time and resources. So take home here is we brought 3 disparate processes closer together through 681. Why do you care if you're not a developer? You care because this also impacts you. Maybe you're not building a subdivision, and that's fine, but you may want to use an exception. And if you drill your well and you put it to beneficial use and then you come into the DNRC to see if you qualify, you might find out at that time, after you spend $50,000 drilling your well, that you don't qualify and you have to go through the permit now. This also helps you because now you have a notice of intent. So instead of having to wait till you put the water to beneficial use, you can and have to apply for a notice of intent. You file for this notice of intent before you use the water. And then at that time, we evaluate whether you qualify for the exception. It's not a water right until you actually put the water to beneficial use and you have a project completion notice, but it does assure you that if it is completed with the notice of intent, it does not affect other permit exceptions. So let me dive in a little deeper. So when do I file a notice of intent? Prior to putting water to use, file for a notice of intent. Well, or after, it's up to you. It's not a requirement. You file a 602I detailing your use. If filing meets the permit exception criteria, we will authorize that notice of intent, and then there also is an extension process as well. So it's just changing when you find out if you qualify for the exception. So instead of after you put it to use and you've invested, it's now on the front end.
So Anna, to clarify, if I want to just put in a well like we used to, I have to do it before January 1st?
No, you can file your notice of intent before, I'm sorry, I can't see you. Yeah, hi. You can file before or after. The timing of drilling your well doesn't matter. You're filing your notice of intent before you put water to beneficial use. The bill does go into effect January 1st. So if you today have a well, you put your water to beneficial use, you might want to file for your 602.
I got to go. No, I'm kidding.
Great question. Step 2, so you filed for your notice of intent. Now you're putting your water to use now. So notice of intent, do I qualify for the exception? Now I used it, file your groundwater certificate, your Form 602, so a notice of completion. It has to be in substantial accordance with your notice of intent. If you are exceeding what you said you were going to do, if you're not in the same place, if it doesn't look the way it looked when you filed your notice of intent, you can expand your use. If it's completed in substantial accordance, you get that certificate. You get your certificate, and it has to be filed within the completion time, or you file an extension, otherwise it expires. Does that make sense? So I think I want a well. I'm going to file for a notice of intent. I have 5 years to go ahead and do that and file a notice of completion. If actually I didn't get the water to use in 5 years, file for an extension. If you don't file for an extension and that time period expires, your notice of intent expires, you're going to have to go apply for another one. Certainty is the hope here.
And talking about 6A1 brings us squarely into a discussion about exempt wells, what they are, what their status is, and I will come back to the notice of intent because I think when we talk a little bit more about exempt wells, that you will see where it fits in. So first, we've talked about existing water rights. We've talked about permits. We've said there are limited exceptions to the permitting system. So what kinds of water uses are exempt from the permitting process? Generally, surface water uses, new surface water uses are not exempt from the permitting process. I have put in here that if you are using direct from source, in-stream, livestock, or domestic uses, and you did not file on them before June 30th of 2019, these were the HB 110 filings, they are exempt, meaning that when that legislation went into effect in 2013, the legislature said, if you don't file on these, it doesn't mean you forfeited it. It doesn't mean you gave it up. It just means you don't have an enforceable priority date and they're subordinate to any other water rights. So this was a decision that people made when they were deciding, do I or do I not file HB 110s or those exempt stock claims? Doesn't matter. Some people filed them, some people did not. I just wanted to make sure that was captured somewhere. It's not really an exception to permitting, but I didn't want anybody to think, my cows have been watering from that river for 150 years. I don't have a water right. Do I have to fence them out? No, that's not what we're talking about. Kind of the meat of the discussion is groundwater uses. So outside of a controlled groundwater area, there are exceptions to permitting for, meaning you can use the water without a permit for emergency fire protection, training, and operations, up to 350 gallons per minute for non-consumptive geothermal heating and cooling. Number 3 is the one that we all talk about, the exempt wells. So less than 35 gallon per minute flow rate, less than 10 acre feet volume from a groundwater well, developed spring, or pit pond. And it's subject to the combined appropriation analysis, which I will talk about more in a moment. There are also a couple other exceptions, livestock pits on non-perennial streams that are less than 15 acre feet in capacity, and groundwater appropriations that were made under the Groundwater Code in 1962. All of this is under 85-306. Those are the exceptions to permitting. So I want to talk about the exempt well law, specifically that 35 gallons a minute, 10 acre feet. I think this is the one that it comes in most often. It's the one people think about when they think about exceptions. I do want to make sure everybody's aware when we talk, it's called, and it has been called in recent litigation in the news, the exempt well law, but we are talking about groundwater developments. This can be wells, developed springs, or pits and ponds. The limit, if your flow rate is under 35 gallons per minute and 10 acre feet per year, you can put that water to beneficial use and you file a notice of completion. So Anna was just talking about, you come after the fact, you say, I've already done it, you get your groundwater certificate that says you can keep doing it. This is where the notice of intent comes in, and Hertha was asking, dude, now what? January 1st, we have this new law. Now you file a notice of intent saying, I'm going to file this well. And DNRC, you file that with intent with DNRC. They have, I think it's 15 business days. It's not very long, 10 business days. It's a short amount of time to get a response that says, yes or no, that will qualify for the exemption. Where I have found with clients that this is important is because of this administrative rule about combined appropriation. What is a combined appropriation? I've put up here the current rule, which is it is an appropriation of water from the same source aquifer by 2 or more groundwater developments, the purpose of which in the department, in the DNRC's judgment, could have been done by a single appropriation. So I have people that come into my office and say, I need a third stock water well over here in this field. Is that a combined appropriation? And I look at this rule and I'm like, I don't know how the department's going to judge that. And that is where the notice of intent comes in. Now, before you've drilled that well, before you've put it in that location, you file a notice of intent and say, DNRC, are you going to tell me that this is a combined appropriation? Because if it is a combined appropriation and your total volume is more than 10 acre feet, the department's going to tell you, go get a permit. So now you have if it's under 10 acre feet and the department says not a combined appropriation, drill your well, move on, it's still in the exception. So that's where the notice of intent comes in, is you are operating as a water user with a little more certainty of, I know I can make this exempt this development, it will be exempt. I'm not suddenly going to have to figure out how to get a permit. You don't have to read this slide. There's a lot of words on it. I believe you got a handout, but my point in this is that we have a very long history of exempt well law and statute and legislation, trying to figure out what is an exempt well, what is a combined appropriation, and what's happened. So highlights of this are that in 1973, when the Water Use Act came online, what was exempt was a well for agricultural, domestic, or livestock purposes under a 100 gallon per minute flow rate. There was no volume limitation. And then in 1974, any type of use, so now it was not limited to domestic or livestock or agriculture, it could be anything, still just 100 gallon per minute flow rate limitation. In 1987, the statute added developed springs as a type of groundwater. We had the combined appropriation rule come into effect, the same one we just talked about. Eventually, in 1993, the definition of combined appropriation changed, and then it said wells have to be, or the developments have to be physically manifolded together. They have to be connected. That's a combined appropriation. In 2006, there was a litigation, Montana Department of Natural Resources versus Trout Unlimited versus the DNRC, that said you have to consider groundwater and surface water together when you are looking at permitting. At this point, the Montana legislature began to say, we need to do something about these exempt wells. In 2014, there was a case that's often referred to as the Sherlock decision that said you can't just consider wells that are combined or that are physically manifolded together. You have to go back to the rule about, in the department's judgment, could this have been done as one project? In 2015, certain types of water uses were grandfathered in. In 2024, we had what's called the Horse Creek Hills decision, most often said when you're doing phase subdivisions, and it could have been one project, you still are limited to the 10 acre feet. In the spring of 2025, this past legislative session, there was a bill, Senate Bill 358, that tried to address exempt wells. I'm sure a lot of you heard about it. It talked about having red, yellow, green areas, closure areas in the state. I want to be clear, this bill did not pass. We do not have red, yellow, and green areas in Montana. That was proposed legislation. It did not pass. That does not exist. The law is as I talked about it just a moment ago. And then in November, there was a lawsuit filed alleging that exempt wells are unconstitutional. And since that just happened, and it was against the DNRC, so Anna cannot talk about it, I'm going to tell you what it was about. Because I think it will shape some policy discussion. You have probably read about it or heard about it. It is very early in the proceedings, so I don't have a lot of answers. I can only tell you what the complaint said or says. And it was a group of plaintiffs, so it was Montana League of Cities and Towns, the Clark Fork Coalition, Trout Unlimited, Farm Bureau Federation, Association of Gallatin County Agricultural Irrigators, Montana Environmental Center, and then certain individuals. Those plaintiffs filed a lawsuit against the DNRC in the state of Montana. What they want at a very high level, they want to declare 85-2-306 3A3 unconstitutional. This is, if I can go back, the third bullet point down, the less than 35 gallons per minute, less than 10 acre feet exception. It is not, at this point, talking about any of the other exceptions. And then the plaintiffs have asked the court to enjoin or stop DNRC from continuing to approve exempt groundwater developments. I think it's also important what the complaint does not ask for. It does not ask to declare the other types of permit exceptions unconstitutional. It did not request a temporary injunction. It did not ask the court, please make this decision now, temporarily enjoin DNRC while you figure out the answer. And it did not ask the court to declare as void all previously issued groundwater certificates. So that's a question I've gotten quite frequently is, if this lawsuit is successful, does that mean my groundwater certificates that I've had from 1974 until now are suddenly void? That is not what the plaintiffs are asking for. I don't have a crystal ball, so I can't tell you what the court will do. I can tell you that generally in Montana, when there are final decisions or final agency actions, which is what I would say a groundwater certificate is, the courts don't generally unwind those and say that they're void. So that, I will pause there. Neither the DNRC nor the state have filed an answer. We don't know what they will say. We don't know if there will be a motion to dismiss. We don't know where it's going. But what I do think is this lawsuit or this discussion may shape policy and discussion in the state moving forward.
So the question I have, so at the end of this lawsuit, let's say that it's successful, so the process is changed, but we do not have a process in place to handle, maybe I'm wrong, but I assume that we don't quite have the process in place in DNRC to handle or if we don't have exempt wells and we have to permit every well that's coming in, is a huge change in the workload. So what happens? Is there a time frame? I mean, there has to be a time frame, and I assume there has to be a legislative fix. So could you maybe expound on that a little bit?
Sure. So the question is, what happens if the lawsuit is successful and the court says this section of statute is unconstitutional, DNRC, stop approving exempt groundwater wells? Then yes, everything would have to be permitted. So if you wanted a small well for a home in the middle of, that you're not in a city, you're not in a town, you wanted to get an exempt well for a home, you would have to go through the permitting process.
Abby, can I add to? So one of the handouts we provided, it says exemptions and permit process. It's the stapled copy. On the last page is the flow chart of what that permit process is for your reference.
Yes, thank you, Riley. So yes, there would be a permit, and the answer, how do we fix that? It would be at the legislature would have to do something about that. They would have to find a statute that says, or create law, draft a statute that says, should Montana have an exception to the permitting process, and what is that exception? The DNRC just does what the statute says. So when they have no choice in the matter. If it's found unconstitutional and they're enjoined, DNRC cannot issue groundwater certificates. Does that answer?
Well, it does. I guess, in my simple mind, things have to keep moving. There'd be, I assume, wells being drilled, and if I don't have water for livestock and I have to drill a new well for livestock, will there be Can the court give a time frame where the status quo is in place until you get a new process in place? Or, the gray area, I guess, is in it, and I'm sure it's going to be gray, but maybe you could clarify it a little bit.
It is gray. I will say, when you hand something over, just generally, when you hand something over to a judge in a court, that judge does what that judge will do. So what I'm about to say is my opinion. I don't know, but I think if a judge were to find it unconstitutional, it's just unconstitutional. I would be surprised to see a judge say there's some kind of grace period for the legislature to figure out what to do. What I would expect to see is, if the judge found it unconstitutional, the judge would say, go to your elected official and tell them you need a fix. And I think it's unlikely there would be any kind of runway to fix it while the legislature works. Hertha, I can see you.
I agree with you. And I would also say that if you look at the time frame, none of us know how fast they're going to go, but courts don't go that fast. So it's been filed now. We probably would get a decision out of the district court where it's filed in Helena, possibly in 2026. That gives us a 2027 session to spend some time to try to figure out what we would do, because it's highly likely, however that court decides it, it will be appealed. So we do have one session to try to get to work on coming up with a solution, would be my best guess. Do you agree?
I do, and I think really my only purpose in this very busy slide is that this has continued to be an issue for decades. So lawsuit or not, it is something that the state and policymakers need to figure out a solution, because litigation and lawsuits, you may get an answer. It may not be an answer anybody likes. And the better way to find something that works for the people of Montana is to go to our elected officials and find something collaboratively.
So we thought it would be helpful to zoom out then as we think about what other Western states do in terms of exempt wells. And what are the suite of tools that they think about to solve the same problem that we're in? And so I was drawing upon my experience working with the Western States Water Council and the Association of Western States Engineers, which are the water resources departments of the West, and some information searching that I've done to try to demonstrate some of the tools that are available to think about exempt wells. So in many Western states, exempt wells are restricted in terms of their purpose. Many are restricted to domestic or stock water uses, sometimes with some small lawn and garden or irrigation. Generally, we don't see a lot of service of commercial, industrial, or subdivision scale irrigation without a permit. So one tool would be to limit the purpose. Another tool is a volume limitation. So small volume domestic or stock, that is again most common we see without that full water right permit, so they can use the exception for a small amount of domestic or stock. But that's coupled as well with a volume, like in Montana, it's up to 10 acre feet. Or Arizona, Nevada is a 2 acre feet, or a certain amount of daily gallons per limit, like in Idaho, Oregon, South Dakota, and Washington. So we do have a volume and flow rate limitation here in Montana, and a lot of other Western states do that as well. Another way of thinking about this, several states, Colorado and Wyoming, for example, instead or in addition to flow rate or volume limitations, have acreage thresholds. So, for example, in Colorado, on tracts greater than 35 acres or more, they can use an exempt well for domestic, serving 3 family homes, domestic animals and livestock, and irrigation of 1 acre of lawn and garden. but parcels smaller than 35 acres and many newer subdivisions only for in-home use. So in addition to, these are not and/or options here, they are, you can put them together. So you can limit the purpose. You can limit the purpose and the volume and flow, limit the purpose and volume and flow in acreage, so you sort by acreage. Another way of doing it is limiting to subdivision and really thinking about cumulative impacts. So if we zoom back out, and why did the legislature in the Water Use Act give us the exception? It was meant for de minimis, small uses that were thought to not impact senior water right holders. And where, again, you're not close to city services, you're in eastern Montana, you just want to put in a well. It was intended to have that be an easier process. And so many Western states have thought about how do we address subdivision uses or cumulative impacts. So when most wells are being used for one purpose, like a subdivision, or we have lots of exempt wells in one place that are cumulatively, collectively impacting a senior water right. So many states, Western states, try to stop subdivisions from multiplying exempt wells or having those cumulative impact by using some sort of concept of combined appropriation or cumulative impact rules, or specifically have subdivision rules or limitations. We are one of those states. I hope you saw from the definition of combined appropriation in the department's judgment could have been accomplished in a single appropriation. You may be gleaning that's sort of vague and maybe ripe to be sued on. And we have been sued on this multiple times now. And so from direct experiences working with our constituents and our staff, I would suggest in the litigation that we've had that this definition of combined appropriations maybe is not the best route or needs some more clarity if it's to be effectively implemented. Others tie subdivision developments to public water supplies, requiring subdivision having water supply plans or designing new subdivisions for connection to municipalities. The recent Idaho bill required this. So the thought here is that subdivisions or high-use areas having requirements to tie into existing infrastructure so that they're not reliant on the exception. Another concept in Western states is public system connections, where they push connections to public or municipal systems when available rather than the exception generally, and it generally has a within or near a service area. We have this in Montana to a certain extent. Some laws also explicitly allow or require plugging of private wells and connecting to that municipal service once that service is extended. So once it's available, you do have to connect in. That is another option too. Another concept is special management areas. You heard Abby talk about Senate Bill 358, where there were red, yellow, and green areas proposed, where red would be closures, yellow were monitoring, green is kind of the statewide status quo. Many other states do this sort of concept. We have controlled groundwater areas here in Montana. Other states have active management areas, like in Arizona, critical groundwater areas in Idaho and in Oregon, basin controls, et cetera. And these are often having that limitation on the use of exceptions in these areas and give the state engineer or the Water Resources Department the ability to deny or not allow exempt wells in those areas. And then finally, to round it out, what are kind of the suite of policy tools available to the state of Montana? Metering and reporting. This was a study done by South Dakota in the last 2 years. 17 Western states were surveyed about methods used for water use reporting, chemistry, stream flow, et cetera. All responding states except Montana reported collecting some form of water use data ubiquitously or uniformly across the state, using combination of different types of methods. And so this is an area that Abby and I both have talked about to you today, where this might be a policy consideration for the state of Montana as well. Metering and reporting of water use helps to protect your water use, helps us know how much is out there and is being used and how that water balance works. So, exempt wells in other western states. A full permit and an exception to the permit process. That is common throughout most western states. The exception has sideboards or limitations in all of these instances, either for purpose, the volume, the acre, what subdivisions can be used for, when subdivisions can use them, requirements to tie into public water supply, closure areas or special management areas, in metering and reporting requirements. Once the state establishes these sideboards or criteria, you are allowed to avoid the full permitting process, meaning you go through a permit light, right? So you've heard, and I think Ray Lee had taken a flow chart of ours on the full permitting process. So instead of having to go through that, you have a light permitting with these basic criterias, and instead have a light form and relatively simple filing. And hopefully that gives you some thought for what sort of recommendations your group wants to make around the exception and what might be possible for the state of Montana. Yeah.
I just was thinking about this lawsuit, and is it a safe assumption that the winning party in this lawsuit will have more leverage when it comes to the next legislative session to form the water bills more to their liking?
I don't know. I don't spend much time lobbying, so I think what will have more impact is that the litigation was filed, and if there is an outcome, especially if it is favorable, I think that will say something to the legislature that something needs to be done. I'm not sure if one side or the other will have more favor. You spend a lot of time up there, but I'm not going to ask you because you're a party to the litigation. So
I'm not going to answer that directly, but I will say that as any of us are thinking about exempt well solutions, and the DNRC is working, and you have a member of WIPIC in the room right now, Representative Minor, and I know they are diligently thinking about how do we solve this problem. The executive is working with the legislative and continues to work with stakeholders on those solution sets. And the litigation frames what are possible solutions that are available to us given this challenge and what it needs to look like. And so I'm not going to say who's going to have more favor, but I do think it shapes what is our solution set.
Would it be safe to say there will be more pressure
on
legislators?
You can say that.
that is my opinion. But I guess in all seriousness, I think the legislature is quite aware that this is an area that needs attention. I think and needs real solutions and to sit down and talk about. And I guess I would encourage the Water Policy Interim Committee does meet throughout the interim, and that is a great place to voice ideas about solutions.
I have a question on other states' solution to using municipal water for a subdivision. Does it require that subdivision to be annexed into that community?
Great question. The question is when there's requirements to tie into public water and supply, does it require annexation in other states? I can't tell you, but what I can tell you for the discussions we've had with municipalities and developers are some of the challenges associated with the cost with annexation. That is often what we hear from the development side, that there is a cost to annexation in those requirements, but then from the municipal side, there are benefits to that annexation and bringing people in. So that is a tension point, and each city in the state of Montana is slightly different on when annexation occurs. Do they require water rights transfers or not? So it is very site specific. But Jim, I didn't answer your question. I don't know. I can look into that, whether or not it requires annexation. It's a great question. I'll put that on the list to come back to. Speaking of things to come back to, the question in the back on Senate Bill 178, can you have a change in point of diversion? I quickly looked up the bill. No, you cannot change the point of diversion with the temporary leases. I'm sorry for not remembering that off the top of my head. It does, yep. But I'm sorry I didn't remember off the top of my head. Yeah, perfect. Representative.
I'll take a shot at Gene's question. It definitely drives a stake in the ground. Now, you guys all know way more about water and water law than you ever thought you'd need to know. But when you get 100 there that don't have any idea, and they have a different passion than we do as far as water is concerned, or they just ignore it. Senator Yakowitz is here, and I'm sure you know more about what you would ever need to know. Now. So it's important information gets out, and when Raylene sent me the invitation to come, I sent it to and to Representative Gist. I seen him in the room earlier. Many people in here, so they need to know how important it is, because when you start talking about this on the floor, you know, legislators zone out. I zone out on some things too, but this is very important. It is my goal to solve before I leave the legislature. So, how much time do we have? Yeah.
And Abby and I are hoping to figure this out before we both retire, too.
So I have a question. Mr. Peterson asked about some big wells in our neighborhood. We've talked about exempt wells permitting, and then, so if you kind of touch on that, I don't know how big they are, but they're obviously big with a big line. And then what Jim might do if he was concerned, or legislation that could be passed to address Mr. Peterson's concerns.
Let me add to this. I think what is lacking is there's really no monitoring or measuring going on, and they're moving a lot of water. And there ought to be some way to monitor and determine the trends. You know, this is going to start, and when they're done, it's going to go from Hobson all the way east, Millstone, and there's a lot of agriculture guys tapping into it as well. Mm-hmm. Everybody's getting a shot at it. So what happens, I kind of think about it, and I think, how in the world is this thing going to operate without some monitoring and management with that many communities involved? Those communities are shutting off their local systems and getting on this one because it's all gravity flow from top to the end.
Yeah. And I think that really speaks to kind of this last slide that when 17 Western states reported back in this study, all of them had some kind of measuring, monitoring, metering except Montana. And this was in the context of exempt wells, but I do some work in Wyoming also, and they have state engineers who measure, monitor, go about. They know who has what water rights, how much. They're out there all the time, and so I think that is definitely a policy discussion for the state. Is, are we to a place where measuring and monitoring and reporting is beneficial, is helpful to both protecting existing water right users, but also making sure that we have any large junior uses that are not negatively impacting other people, especially when you look at junior uses that are for in-house domestic, and there's this tension because you don't want to take water out of people's homes, but you also want to be able to keep irrigating. Yes?
Not to talk too much here, not to talk too much here, but in my area, there are a few of these big wells that are artesian. And you measure the artesian and then later on put a pump in there with it. It's hard to manage the impact or how much water is really getting there. And it has to be on the output side to kind of look at it.
I want to add two different things, and going back to your original question, what can the legislature do about it, or what can be done? So in existing statute today, 85 to 506, 506 is the Controlled Groundwater Area Statute, and if I miscite that, I apologize. I think it's 506. There is the ability for communities to petition for a controlled groundwater area for water availability problems, water quality problems, for a slew of problems. I think you're talking about this study that was passed last session that MBMG is looking at aquifer levels in your area. Is that the? Yeah, so the MBMG is conducting a study right now to look at aquifer levels. My best understanding is that that study will be a year out. We've collaborated with them to help to ensure that the data they collect we can use to think about and integrate into water availability questions that we analyze. Then there's a kind of a suite of options. There could be a citizen-driven closure based on the information and impact to users. There could be a DNRC one under 506 as well, or there could be a legislative closure as well. And so last session, there was a discussion about a closure area, and the decision by the legislature was to actually have the study be done in order to understand kind of what are the appropriate next steps there. So I think there's a suite of options, and I believe MBMG within the year will have a study and those results to the Water Policy Interim Committee. And then in terms of metering reporting, this was generally not just about exempt wells, but generally across the state, these 17 states. So not only in addition to exempt wells, metering reporting generally we don't do as well, only unless it's needed for a criteria associated with a permit. So universally, we don't do this. I can say, and then going glass half full here, the state of Montana actually has a really good, robust stream gauge network, which is not water use, but like the physical availability or stream gauges. The Montana legislature passed in the last two sessions significant funding for a state-based network. We're building out to 100 stream gauges. So from that data side, we're doing really well. From the water use side, as you've already highlighted, there needs to be some real policy choices there if we want this information to help our management decisions.
We have time for one more. Butch?
Yeah, Butch Gillespie, Senate District 9, probably for Anna, but it came up in public lands this morning on federal land, but getting back to state land, is there a guaranteed safe way, I know this has been kicked around for a number of years now, that we can use our private water on state lands without the risk of losing it at some point down the road?
Thank you, Senator, for the question. I am going to give an org chart of the DNRC, and the State Trust Lands and Forestry Division, I believe, will be here later today, and I think they're going to be talking about this issue directly, and I really would love to defer to them on answering that question. How's that for a punt?
We unfortunately better wrap this up. We'll all move upstairs immediately, 20th floor, and we'll probably just almost pick up where we left off. So anybody that wants to be part of the committees, head on upstairs. Thank you, everyone.
Thank you, guys. Thank you.